see you all. First of all, before we start, I'm just going to give the rules and regulations and introduce you to the table here so that you know who you're speaking to. Notice is hereby given that a meeting of the licensing subcommittee is held today on the 6th of November. It's 10 o'clock, but we're a little late, so 10 past 10. I'm Megan Barrow, District Councillor here in Cotswold. I'd like to introduce yourself.
I'm Rita Heseltine, Councillor for Purton Lakeside, and I'm a Cabinet member. My portfolio is regulatory services.
I'm County Councillor Bernard Williams. I represent Frank Worley, Chesley High and Ewell areas around there. So it's our Staffordshire District Councillor, Chesley High.
Morning all, I'm Rebecca Cooper. I'm the legal advisor to the committee this morning.
John Chisley, I'm the licensing officer for South Staffordshire Council.
Thank you, everyone, just so that you know who you're talking to. Item 1, the minutes of the last meeting to be approved. The meeting was held on the 4th of July. Any objections? Everyone happy that I signed these minutes? Apologies, to receive any apologies for non-attendance. Well, I think we're all here, so that's fine. Declarations of interest. Are there any declarations of interest? Just at this stage, I will just say that I have been dealing with Pattingham for a stall at Cotswold Christmas Fair. I haven't met them personally. Their money was paid straight into that account, so I have nothing to do with it other than put their name on the stall. Is everyone happy with that? Anyone has any objections? Just wanted to declare an interest. Thank you. Licensing procedure. Yeah, it's all in the pack. If you've all seen it, it's all been online. If there's anyone that wants to ask any questions, I'm sure our two officers here would be more than happy to help you. It's the normal procedures. We have a chair for this meeting.
I'd like to nominate Councillor Barrow.
Everyone happy with that? I am chair of the district council here, so this is my chair. Item 5, application to vary the existing premises licence at Pattingham Vineyards, Greatmoor Road, Pattingham. We go now to the licensing officer, John, please.
Thank you, Chair. This is an application to vary the existing premises licence for Pattingham Vineyard. It was received by the gov.uk portal on the 25th of July this year. This was forwarded to the other responsible authorities. Notices were displayed and was advertised in accordance with the requirements of the Act. The application and plan are attached as Appendix A and A1, pages 13 to 31. The variation application form states the application to vary the existing premises licence to include the following: a small bottle shop for cellar door sales operating Monday to Saturday 10 till 4, allowing for on and off sales for the purchase of bottles of wine to take away or by the glass. 2 special events, all pre-bought, operating Monday to Sunday 10 till 8. This provision would allow occasional events that may happen. Examples include corporate events, team building, private celebrations, Christmas workshops, etc. The vineyard tours and wine tastings operating Friday to Sunday 12 till 7. It's noted the same days and times as the current licence, so there's no change to those, apart from extending the number of people from each tour to change the permitted numbers from 12 people to 20, again all pre-booked. The supply of alcohol on and off sales Monday to Sunday 9 till 8, and the premises opening and closing time 10 till 8 Monday to Sunday. It's the understanding of the licensing authority that the application for the premises licence has been properly made. The statutory requirement to give notice of the application has also been complied with. There's no outstanding representations have been received from any of the responsible authorities. There has been representations from 27 local residents from 15 different households who live in the Greatmoor Road area and have received by the licensing authority, and copies of their emails and letters are attached as Appendix B, page 33 to 59. The letters and emails state the grounds for representations are made against the licensing objectives of all 4 licensing objectives, but principally the prevention of public nuisance. The applicant's agent was notified of the objections, and copies of the objections, letters and emails were provided. Pattingham Vineyard was granted a new premises licence by the licensing subcommittee on the 10th of August last year, following objections to the grant of a new licence by local residents. A copy of the licence that was granted is attached as Appendix C, pages 61 to 70. It's also noted that late on Friday afternoon, on the 3rd of November, that Mr. Craig, representing the residents, have emailed the licensing authority and the agent representing the applicant. Copies of those emails and proposed conditions are attached. Copies have been provided to members of legal, and I understand that Mr. Stemper from the licensing guys has also received a copy. And that concludes the licensing report.
First of all, is there anyone who wants to clarify anything on the officer's report? Everyone's.
Yeah, there is one thing, and it only really occurred to me over the weekend in a significant way. I've done a bit of back and forth this morning. I'm unclear. The application, if you look within the agenda pack, there is, with me, page 28. There is what is the existing barn, and obviously you've got the red area there highlighted for licensable activity. Licensable activity being simply the sale of alcohol by retail. And if you turn to page 30, you've got the new barn, what's described as the new barn. Now this is either, and then what was sent in last year is that, which is the existing barn. So what this application is, or I'll say what I think it is in a second, but based on that plan that's been submitted, it is either an application to add the new barn to the licensable area, which is effectively to increase the licensable area, or alternatively, it is to substitute the existing space with a new space, in which it is both to change the licensable area and, obviously, given the fact that there are 2 floors rather than 1, to increase it. Now, what's confused me about this is that I can see no reference whatsoever to the licensable area changing or being subject to any change at all in the application itself. Gone through it. If I've missed something, I apologise. It's not completely unheard of, but page 8 in the application in the agenda pack, which is the description that's been ascribed by your licensing authority acting as a in an administrative capacity. It describes what the nature of the application is. It's to a small bottle shop for cellar door sales, unless I mean, potentially, I suppose the sales could take place from there, but even so, my point doesn't really change a great deal. Special events, to increase or to incorporate special events as part of the scope of the license, and to have vineyard tours. I then invite you please to turn to page 16 of the agenda pack. I don't need to really read that out. It essentially says the same thing. And above that box, it says, describe the premises, for example, the type of premises, its general situation and layout, and any other information that could be relevant to the licensing objectives. Now, that is lifted, in fact, from Schedule 5 of the Licensing Act 2003, Premises License and Club Premises Certificates Regulations of 2005. So it's from the guidance that authorities and applicants need to adhere to. Then please, page 18, the application, obviously that deals with the hours for the sale of alcohol, as does page 19 and 20. 21, it says identify those conditions currently imposed on the license which you believe could be removed as a consequence of the proposed variation you're seeking. No provision is made whatsoever in there in terms of a change, any change to the licensable area. And lastly, in respect of this, well, I don't need to tell you that's page 30. I've already taken you to that. Now, I then this morning checked the advert which one of my clients asked to be sent over. The advert was placed. By the way, I'm not making a point here that the application isn't valid. I'm not saying that, because your licensing authority have great powers of discretion. If they think it's substantially compliant, that's as far as I'm concerned, that's the end of it. Unless they've made some egregious error as to the law, and I'm not saying for a second they have. But the application itself, the advert itself, makes no reference at all to the change in the licensable area. It just simply says, did you describe the nature of the application on and off sales of alcohol between 0800 and 2000 hours daily to allow on and off sales from an on-site bottle shop open from 10 AM to 1600 hours, and occasional events, increasing max numbers attending vineyard tours as per pre-existing premises license from 12 to 20. That describes the nature of the application. I then done this before. I've looked at the guidance once or twice, but I didn't look at it in this context before. 8.62 in the guidance. This deals with applications for variations of licenses. Please. .62 says many small variations to layout will have no adverse impact on the licensing objectives. However, changes to the layout should be referred to the full variation process if they could potentially have an adverse impact on the promotion of licensing objectives, for example, by increasing the capacity for drinking on the premises. So that sort of points towards the fact it should be part of the full variation. 8.80 in the guidance. Just deals with the advertising of applications. And then 8.82 says the summary of the application should set out matters such as the proposed licensable activities, the proposed hour of opening, and should be clearly displayed for the period during which representations may be made, together with information about where details of the application may be viewed. So my point that I'm arriving at is that I can see no basis for the change in the licensable area, be that an addition or a substitution, to form part of this application, because it does not form part of the application. It doesn't. It can't, because it's not in the application form itself. It's not been provided for in any of the adverts, and obviously adverts on the basis upon which people can make representations. People will look at it and go, well, I'm fine with that, or I'm not fine with that, based on what is in there. It doesn't have to be chapter and verse, but it has to contain the fundamental matters to which a license is subject to variation. So I think it's right, Mr. Semper's obviously got the right to respond to that, but I don't believe, professionally speaking, in my view, that is in any way part of the application, and therefore not something you have the power today to determine upon. There's nothing preventing the applicant submitting another application. But I thought it right to point that out at this particular stage. You obviously need to take legal advice on that, and quite right that you do. It's also absolutely right. Mr. Semple has a right to respond to what I've said, but I thought it right to point that out at this stage. And in saying that, I am not making any submission. The application isn't valid. We are here today. We are here to determine it. I'm not going to get into litigation about what was displayed and what was advertised in terms of where the blue notice was, how many there were. That's been dealt with. What I am dealing with is the substance of the application at this stage. And so I felt it best to point that out now. Thank you.
Thank you. If you could just turn
Sure.
your mic off. You'd like to respond?
Surely, okay. Let's go back to the application itself. Line 4, it says the owners would like to add to the current provision in the following manner: a small bottle shop for salads or sales, and the operating time. Now, this premises is already, there is a barn there already, and the new barn is not built yet. This is the plan. Okay, on page 1, it shows where the existing barn is with a blue and a red barn for the new one. Okay, a red block for the new one. On page 2, it shows you the licensable area for the existing barn because they wish to trade this new variation as of now. Page 3 shows a map. And page 4 shows the new barn. Okay, so therefore, it has never been concealed at any point in this application process that there was an intention, A, to continue trading out of the existing barn, and then to add a new bottle shop in the new barn that's not built yet, which is shown on page 4. Okay, now referring back to para 8.62 for your legal advisor, small variations of layout will have no adverse impact on licensing objectives. However, changes to layout should be referred in the full variation process if they potentially have an adverse impact on the promotional licensing objectives. I do not believe that what is proposed within this does have an adverse impact on the promotional licensing objectives, and that is what you must decide. But in the meantime, at no stage has it been queried by planning, by the licensing authority. At no stage has the inclusion of the new barn. It's been shown right from the beginning of this application. That's what we intend to do, and that is my position, members of the panel. Okay, my submission is the plan is part of the application. Okay? It's part of the whole application process. Oh, sorry.
Sorry, yes. We have to remember to switch them off.
We just,
Rebecca's just going to make a comment on those.
Well, yeah, just to give you some advice.
Yeah, yeah. Just one moment. Obviously, we're just debating the issue that you've raised. We don't feel there's anything untowards here in the application. We feel that all the way through it, they have actually explained it quite well and included everything that was necessary. Okay. Members, do any of you wish to ask any questions? Rita, Bernard, is there anything that anyone wishes to ask?
Do you want to ask Mr. Craig to address the committee then?
Mr. Craig, would you like to address the committee? Sorry, Mr. Craig, I'm looking at you. Sorry, Mr. Craig.
Nick Semper of the licensing guys, a licensing consultant. I'm representing Passingham Vineyard in their application for a variation to their premises license, which is before you today. Passingham Vineyard was founded in 2018 and covers 12 acres of land with some 20,000 vines, comprising Solaris, Saval Blanc and Pinot Noir varieties. The vineyard is on land at the rear of the residential property. This is a modest operation as vineyards go. And despite its relatively short history, has received a medal from the Wine GB Awards last year for their Nurton Brook wine. It is a young, small-scale, quality operation and has attracted discerning customers since it has been able to sell its products. Now, the intention line behind this variation is to expand modestly on their existing premises license, which was granted here by a subcommittee on the 10th of August 2022, following a contested hearing involving some of the same representatives as in this variation application today, who have made very similar representations to those which lie before you today. Now, specifically, just to reiterate on what John Chislett told us, we would simply like to add a small bottle shop for cellar door sales operating Monday to Saturday, 10 until 4, allowing for on and off sales for purchases of bottles of wine to take away or by the glass. Secondly, we'd like to do some special events there, all pre-booked, operating Monday to Sunday, 10 until 8 o'clock at night. This provision would allow occasional events that may happen. Examples include corporate events, private celebrations, Christmas workshops, etc. And thirdly, vineyard tours, wine tastings. These operate on Friday to the Sunday between 12 and 7. And nothing's changing between what we're asking for today and what is on the pre-existing license, save that we're asking to up the numbers from a maximum of 12 persons per tour to 20. Again, all pre-booked. Now, why would they want this variation, you may ask? This business is run on a mostly internet-based pick, pack and dispatch operation from a small barn on site, providing a route to market, which was only available prior to the grant of a premises license via third-party sales platforms. However, occasional visitors do arrive on site wishing to make a purchase, and this small bottle shop will enable those sales. Please understand, this is no JD Wetherspoons that we're proposing here, but a small bottle shop selling only the vineyard's own products. The bottle shop will be sited initially in the present barn and then later in the new barn when it is built. That is why there are 2 barns shown as licensable areas within the accompanying plan. Permission of the planning authority to add this additional barn has already been given. As in April of this year, the head of planning for South Staffordshire, Jennifer Mincher, she wrote to tell the applicants that no additional planning permission was required for the intended new structure. The applicant would also like to conduct occasional special wine tasting events, whereby small groups can book to see the viniculture taking place, appreciate the provenance and the processes involved in producing these quality products. In the application, they're described as corporate events, private celebrations, or Christmas workshops. These will not be large, but rather intimate events for discerning customers. Types of organisations we envisage are the Penn Choral Society, the Pattingham Bell Ringers and the Tetton Hall Watercolour Group. They will, by agreement with the representatives, these special events, by agreement with the representatives, we had a public meeting a week ago or so, will be limited to a maximum of 30 persons attending those events. And those events will take place in the new barn structure. Lastly, they've been running small connoisseur vineyard experience tours twice a day between 11 and 7 on Fridays, Saturdays and Sundays between May and October. At present, these are limited to no more than 12 visitors per tour, all being pre-booked online. The applicant would like to increase that number to a maximum of 20 and be able to sell wine by the glass to these visitors and make off sales to them at the end of those tours. Now, as you can see, members of the committee, this application is almost de minimis by its very nature and simply is not capable of generating the sort of issues feared by the representatives. In this application, the burden is on the applicant to show that the proposed variation, supported by the pre-existing operating schedule, as varied, is capable of promoting the licensing objectives and will not undermine them. Any representatives still opposing the application, on the other hand, have the burden to show that the premises, these premises, trading under this operating schedule will undermine the licensing objectives and demonstrate that with evidence. In our submission, any subcommittee properly advised can only refuse this application if they find, on the evidence of the representatives, that the operating schedule, as amended, is not capable of promoting the licensing objectives. Now, each application must be judged on its own facts and merits. Significantly, there is not a shred of evidence in the representations or arising from them and before you today that challenges or criticises in any way the operating schedule, the premises themselves, or the way it's been traded, the applicant, being the premises licence holder, or the designated premises supervisor. So, representations have been received from 27 residents of the village, together representing 15 households, to which I shall respond to in great detail shortly. Helpfully, they have all provided identical, almost generic documents, so they can effectively be dealt together as one. Firstly, however, actually much more significantly, I will now demonstrate who has not made any representation and must therefore be content with the application and satisfied that it is indeed capable of promoting the licensing objectives. Firstly, the licensing authority themselves, acting as a responsible authority and responsible for licensing in South Staffordshire. They make no objection. The police, who are your primary source of information and evidence on all crime and disorder issues and ASB issues in South Staffordshire, nothing. Environmental health, who lead on quality of life issues under the public nuisance objective. The planning department, which deals with planning and permitted business uses of premises in South Staffordshire, and neither do the highways department. Because the highways department, they deal with traffic issues and they have no issues with this application. Trading standards, who deal with underage sales of alcohol and any other trading issues, and public health, who deal with substance abuse, likewise have no issues. And lastly, Children's Services and Safeguarding Board, responsible for the protection of children, they have no objection. I've made due inquiries of Mr. Chislett of the licensing authorities, asking whether anything has been amiss since you were pleased to grant the premises licence back in August 2022. He reports not, and further confirms that absolutely zero complaints have been received from any party whatsoever, including the representatives, concerning the operation of these premises. Mr. Craig, for the representatives, has been kind enough to concede that point at the public meeting last week. So it's both a logical and compelling conclusion that all of the responsible authorities for South Staffordshire are satisfied that the application and its attendant operating schedule, as it now stands, is capable of promoting the licensing objectives. Otherwise, they would have made representations and would be here to argue vehemently against it. Further, it is clear that these responsible authorities using all of their expertise and knowledge of the area in which the premises are situated, are satisfied that this application will not undermine the licensing objectives in any way. Turning to the representations themselves. Each of these 27 mirror representations claims it is founded upon concerns in relation to all 4 licensing objectives, but principally the prevention of public nuisance. However, members, that is where every one of those representations stops. There is no specific mention of the prevention of crime and disorder, the protection of children from harm, or public safety in any of them. Even the prevention of public nuisance, the so stated principal concern, gets scant mention after the 2nd paragraph. Save for the belief that, if you were to grant this variation today, the application would significantly undermine it. That assertion is wholly unsupported by any evidence, either in the representations or arising therefrom and before you today. The representations can therefore clearly be seen as entirely based on fear and speculation alone, and I invite you to disregard them in their entirety. The representatives complain that this variation goes beyond what was permitted by the pre-existing premises licence. Well, we cannot argue with that, else what is the purpose of us asking for a variation other than to add additional facility to this premises licence? They further complain that there's been no prior engagement. Well, we have actually invited them by letter, all of them, to visit the vineyard, but apart from one person, nobody came back to us on that. And frankly, people can hardly be surprised because the applicants fully expected these representatives to object to their application, as indeed they have done. What I would ask is what is the point of engaging in negotiation with parties when you know, based on everything that has gone before, that whatever your proposals may be, they will be found to be unacceptable by the other parties? The applicant is fully aware of the previous concerns that the representatives aired at the last hearing. These centred on vehicular traffic volumes, the possible theft of agricultural machinery from their site, planning concerns, regulated entertainment, large festivals on the site, and risks to children. All these issues were thoroughly explored at the last hearing and were found to be either irrelevant or so remote a risk as not to undermine any of the licensing objectives or be a bar to your grant of that premises licence. The notion that the applicant has sought to expand their premises licence by stealth is frankly for the birds, as this application has been duly submitted, publicised and advertised, and has resulted in this very public hearing and the 27 representations against. Now, these representations contain no evidence or even suggestion of any breach of the current premises licence conditions. This is a variation application and not a review in any event. And although the representations reference all 4 licensing objectives, they fail to describe in any way if and how they could have been undermined now or at any time since the grant of the premises licence, or could or would be undermined in the future if this modest variation is granted. And this, members of the committee, is an evidence-based decision-making process. There is simply no evidence before you, but just more fear and speculation as to what might happen at some undisclosed point in the future were you to grant this application. In the highly unlikely and improbable event of future problems actually ever occurring, then the representatives and the responsible authorities for that matter would have recourse to the statutory remedy to any and all such problems, being a Section 51 review procedure with which you are already familiar. Now, on Wednesday, I don't know if I'm coming in and out on this microphone. I'm leading in. Can you hear me? Oh, that's right. Stop sharing. On Wednesday, the 25th of October, we met with the representatives at their invitation, together with their representative, Mr. Craig, at Pattingham Village Hall, in order to discuss their concerns with them. During that meeting, we explained that all tours and special events are pre-booked via the Vineyards website. We were asked by the representatives how many tours had occurred in the past year, as they believed there had been 2. We were able to inform them that there had been 20. This amply evidences in the clearest possible way that these tours do not cause problems in the vicinity of the vineyard, else the representatives would have had a clear understanding of the volumes of the tours undertaken and evidence of repeated foreseeable problems. 90% of these tours that have taken place have gone completely unnoticed by anyone except those participating in them. Still further, the 10% thought to have occurred by the representatives gave no rise to complaints, reports, or problems whatsoever. Now, Mr. Craig also asked us to consider a traffic management plan in the operating schedule, and he's come up with some suggestions that were emailed, bounced between us. The applicants simply cannot agree or attempt to agree to manage traffic anywhere outside their own premises. To do so would be unlawful, as this traffic runs on a public highway. What they can do and what is within their control is already contained within the current licence itself, which we were pleased to grant, which states that tours must be of 2 hours duration and each separated by a 2-hour gap. In doing that, any impact of traffic connected to the tours is minimised, as it leaves that 2-hour gap for attendees to clear the area in their vehicles, so that leavers leaving one and attendees or arrivers coming to the other will never conflict. Concerns were raised regarding the volumes of persons attending special events. And this is at that meeting. The applicant readily accepts Mr. Craig's suggestion that the maximum number of attendees to attend such functions be limited to 30. Lastly, at the public meeting, one representative maintained that the inclusion of the word occasional regarding the special events within the application meant that every day could be an occasion. With respect, that is taking the word occasional in entirely the wrong context. To that end, I would draw the panel's attention to the dictionary definition of occasional in its intended context, which is not happening often or regularly. Mr. Craig has subsequently served on us a request that we consider the addition of 4 further conditions unto the licence, namely the premises have an active management plan. This is impossible as the premises as the applicants can't control traffic on those roads. And we've got that 2-hour separation between the tours already that you put on the licence last time. Secondly, he asked any events other than wine tours have no more than 30 attendees at one time. We've already agreed that. The third one is that there shall be no amplified music or speakers on the premises. Now, this would constitute a blanket ban on all radios and ambient music on site. Regulated entertainment is not currently on the present premises licence and bears no part of the new application. So no, we don't accept it. And lastly, any pre-bookings for special events and wine tasting tours shall be undertaken online in advance of attending the premises. This already happens and will continue. It is implicit in the meaning of the word pre-booking. Now, lastly, Mr. Craig served on us on Friday a set of photographs of machinery on the site. I feel almost nostalgic because these pictures date back to 2021 and form part of the then planning application made prior to the current existing barn being built. The pictures do not reflect the current situation, as the machinery is now stored in the barn and which was subsequently built and in accordance with the condition placed on the current premises licence. You with me? Okay. In the event that this variation is granted and the new barn built, the public will no longer have access to the existing barn where that machinery will continue to be stored. Okay. Right, so the raising of that issue is in my submission, and massive respect to Mr. Craig, for whom I have a lot of time. that's wholly irrelevant to the application. So in conclusion, what I'd say is this hearing today is simply about whether this premises license, varied as requested and operating under this operating schedule, is capable promoting the licensing objectives. Clearly, my position is that it is. It is a small scale quality operation which has not to date and will not in future impact adversely on anyone. Consequently, I respectfully request that you grant this application as sought, supported by the already comprehensive raft of effective conditions, and in doing so, you wish this modest but successful vineyard every continuing success going forwards. Thank you very much. Thank you. I've done it again.
Can I ask you, will anything be done outside as far as this application is concerned?
That's a really good question, Sid. What happens is that these guys do a lot of sort of food fairs and farmers markets that they take place under the authority. Yeah, we know no issues.
Oh, no, okay. And the other thing is, how far is this from the properties? Let's move on.
Place where the licensing. Some people are closer. That.
Okay.
And that's pro.
You're saying the police are happy on this?
Okay. I didn't hear it. Are the police happy?
Yes.
Yes, the police must be happy and they want the objectives.
Okay, fine, thank you. Sorry.
You might just say that this is no, as in this I don't know. The reason for increasing the number on your twos from 12 to 20, is that because of the popularity, and have you had to perhaps refuse some applications because you haven't been able to cater for that many people? Is that one of the reasons you want to increase it to 20? Just a quick one as well. For your special events, obviously they're going to be a bit larger. Would you need to get environmental health involved to come and inspect to make sure that everything was in order? Or would that not be appropriate?
The only concern I have is selling the alcohol by the glass when you're selling the bottles, obviously. How do you envisage that happening? People just standing there and drinking a glass of wine? Is this wine they bought, or is it a taster, or what is it?
Yes.
Yes. You talk about 30 people. Can I ask, are you only looking to have groups of 30, not individual people booking and coming in ad hoc?
Well, obviously increasing the amount of people, how does that affect parking, etc.? What would happen though if it becomes even more popular? Because obviously you're going to get more people coming to 30. Can you accommodate extra cars other than the 10?
But please understand that we've already exceeded to Mr. Craig's request. We put a top on it. So even if there's 50 people trying to book on, we accept.
Mr. Craig, have you got any questions?
I had a few, but actually Mr. Semper's addressed most of them, so I'll deal with them when I make my presentation. I just want to be clear, the planning documents, planning and licensing are separate regimes before Mr. Semper points that out to the room. But obviously public safety is one of the 4 licensing objectives. Obviously I'm here to represent the number of residents. They've expressed concern to me. This agricultural building for storage of associated machinery and equipment that's contained in this planning application, is that on the plans, is that the existing barn or the new barn? Just to be clear. Right. And as part of this application, because I'm still slightly unclear, is the existing barn still going to be used as a licensable area going forward? So I'm here to ask questions, Mr. Semper. Please let me do my job. Okay. So I've asked 2 questions. I've got one more. So that area that's the agricultural building won't be used going forward as part of licensable area. Is that right? Very well. Right. Thank you very much. Thanks. what then I suppose I was further question. I've obviously finished my line of questioning in respect of that. So in terms of that particular area, what would the position be? I mean, what the concern that's been raised is within the planning, the ground floor will be utilised for the storage of equipment such as a diesel tank. I mean, obviously there's photographs that sort of reflect that to some extent. Is it the case that what is the position with regards to a diesel tank in that area? Right. And so there will be no diesel tank at that point. Thank you very much. Cheers.
Are there any more questions that either side would like to ask? No, no. Mr. Craig, would you like to sum up to the committee? Sorry, submissions, sorry.
So, right, okay, fine. Right, let's deal with the substance of the objections. Obviously, first of all, Mr. Semper's suggested that the objectors are a homogenous group of people, and they aren't. Obviously, what I've endeavoured to do is raise collective concerns, but it's right for me to say there's 27 objectors, and whilst their representations might bear some similarity to each other, that doesn't mean they don't have different concerns. And that was one of the things. We had a meeting on the 25th of October. Mr. Semper and his client were kind enough to attend, and various concerns were raised with me before that hearing, and then we had a talk when Mr. Semper turned. There was a bit of a mix-up about the times, and apologies for anybody to that. But anyway, it was a reasonably productive meeting, I felt, even though there's still points of difference between the parties. And then, obviously, what my job is to do is to sift through what is relevant and what isn't relevant, and to obviously advise people who aren't involved in the licensing process day to day, as I am, what I can and can't achieve from this process for them. And so that's why you have those conditions that are proposed, and I'll turn to those shortly. But I'll just deal with some of the points that Mr. Semper has made. First of all, the fact that there's no other representation, there's no representation from any responsible authorities, all the guidance is clear on that point, that they should be the main source of advice for you in terms of your deliberations today. But of course, Parliament has allowed members of the public, be they local residents or otherwise, to make representations upon a variation application. That is local democracy in action. It is absolutely right. When the Licensing Act came into force in November 2005, there were a couple of principles that underpinned the ethos behind the Act. A number of them, but two principal ones, I would say. First of all, that local councillors, such as yourselves, who have local knowledge, who are accountable, who are democratically elected, are involved in the decision-making process when there's a dispute over a licence, as there is today with this one. But also that local people would be engaged with that process and would be engaged with the democratic process, because at the end of the day, licensed premises provide a lot of benefits. They bring people together. They are good for the local economy. Mr. Semper has described many positive aspects from his client's point of view about these premises, but also licensed premises can negatively impact upon people. And what a licensing hearing is about, and the determination that arises from a licensing hearing, is a balancing exercise between those two concerns and those two, I guess, to some extent, competing interests. And so it's wrong to say, just because there's no responsible authorities involved here, that that's the end of the process. It's not. These residents have all collectively and individually raised concerns about this application. And I just want to say that at no point in my interaction with Mr. Semper, no point in my interaction with Semper and his client, and that both goes face to face and in emails. Never been any suggestions for me that this variation shouldn't be granted. I think that would be a submission. It would be an ambitious submission of mine. It's not a particularly extensive variation, but the fact that you have this number of people making objections is something that you should absolutely take into account. And whilst Mr. Semper's endeavoured to apply the Thwaites case to these proceedings, which talks in a very abstract sense about evidence, the position in relation to evidence, yes, you are have to base your decision evidentially, but evidence is about concerns being raised about the area, people's local knowledge, their genuine concerns, and then evaluating those concerns. Let me give you an example. If I wanted to open a nightclub next to your house, and till 4 a.m. with people spilling out onto the street, and I turn around and you objected to that, and you turn around and I turned around and said, well, there's no evidence that this nightclub that's going to open till 4 a.m. is going to cause you any bother and any mither in the wee small hours. Well, that would be an absurd submission for me to make, because by its very nature, a nightclub is likely to cause those particular issues. So I don't agree with what Mr. Semper said about the fact that just because the variation hasn't taken place, that doesn't mean that there aren't genuine and real concerns that you can quite properly address. So I'll just make this point as well. Mr. Semper said that there was no point engaging with people. Well, there may have been some point, because it may have been that some of these matters could have been vocalised and ventilated, and the issues could have been narrowed. But look, we are here today, and that's the purpose of you to determine this application. So really, what we're here as far as my instructions can properly take me is in respect of those conditions that have been proposed. So how those conditions came about is as follows. I went to the meeting last week. I had a truncated half-hour meeting with the objectors. I very quickly, ferociously wrote down all their concerns, and I said, well, we can't deal with that. That's not relevant. I think that's a valid concern you've got. And we narrowed the issues down. And then the applicant came in, and I had a few questions just to clarify what the nature of the application was. And at that point in time, I then said to Mr. Semper that I would email him once I'd sort of got a bit of clarity around the instructions, and I did that. And he responded on Friday, as he's perfectly entitled to, as the client's perfectly entitled to, saying that they weren't prepared to accept any of those conditions. Now, I'm a little baffled about a couple of those for this reason. First of all, I'll deal with them in the order that they appear in my email. Mate, you might have to excuse me. I've got a new laptop and I've got a new password. It's, hang on. I can remember them anyway while I do this. So the first one is about an active traffic management plan. Now, a couple of things. First of all, the most common concern that local residents had was about issues around traffic. They say that the premises where they're situated, the roads that are around it, gives concerns around public safety. Now, Mr. Semper's quite right. Once patrons pass beyond the control of the premises, that's not their issue, that's not their concern, and the guidance is clear on that. But it's equally correct to say that people leaving a licensed premise, be that by car or otherwise, once they pass beyond that point, can have an impact upon the surrounding areas. And at that point in time, when people leave the premises, it's perfectly normal in certain circumstances for that to be to engage the licensing process. I'm going to give an extreme example, but of course, Glastonbury, for example, I'm not for a second suggesting this resembles Glastonbury in any way. You have tens of thousands of cars leaving. That needs to be managed in a particular way. Now, all that condition requires is that there is an active traffic management plan that's suited to the premises, that's suited to the numbers. Well, what the applicant and Mr. Semper have described to me is a traffic management plan. They've said we have a 2-hour gap and we look to manage it and we don't want to increase. That's a traffic management plan. I'm not prescribing, and nor am I in any position to prescribe what should be in that. All the objectors are asking me to submit to you is that there is something down in black and white that seeks to manage the traffic as it leaves in order that public safety can be promoted. If the applicant then considers that to be 3 short lines that deals with that adequately, that's no business of mine or frankly the objectors to interfere with that. They've got to run their business as they see fit. But that addresses that concern. And if that isn't then sufficient and something goes wrong, well, that's on them. And if it is sufficient, that's the end of the matter. So I fail to see why that has been rejected in the way it had, when actually it's something that might provide a level of protection for the license holder, and to say, well, look, we've got this traffic management plan. We are managing it in the best way we can. I'm not seeking to say what should be in it. I'm not seeking to say how big that document should be. All I'm inviting you to do is impose a condition on there that is managed in a way that addresses the concerns of the local residents who are here today. The second of those conditions that's proposed is that for events other than wine tours that will have no more than 30 attendees at one time. Well, that's what Mr. Semper said is the ambit of the application. That is the application. They don't intend to, and that obviously that condition followed from the meeting. We were expressly told we don't want to have more than 30 people there. So in order to address the concerns that the objectors have, all I'm asking is that is committed to the license by way of an enforceable condition, in order that all of a sudden we don't have 300 people there attending an event other than a wine tour. My clients are just simply seeking to limit that in a way that is enforceable and precise and clear. Again, the third condition is that there will be no amplified music or speakers at the premises. Again, that follows from what the applicant said to us at the meeting, that there's no intention to do that. That was again a concern that was raised by the residents, that a number of them, particularly those that live relatively closely, felt music carries quite well, or quite when the works were going on and people were talking. There's nothing we could do about that, but the noise from that venue carries quite a lot across the fields. So all I'm seeking to do by including that is enshrining what the applicant has said is their intention with regards to the scope of the application. They said we don't intend to have any amplified musical speakers at the premises. Well, all I'm seeking to do is reflect what was said at the meeting by the applicant. And lastly, I don't agree, Mr. Semper. What is a pre-booking? A pre-booking could be somebody literally turning up and saying, "I'll pay now and I'll go inside in a minute." And again, my clients have a concern, and the objectors have a concern around that, just wanting that to be defined in a way that's more clear, so that everybody knows what a pre-booking is, because otherwise it's not enforceable. And frankly, if we don't know what a pre-booking actually is. I would also, lastly, as a consequence of what's been said, write a further condition, simply that area, once it ceases to be, if the intention is for it to be ceased to be used, is a condition that's delicensed at the point the other space is utilised for licensable activities, in order that you've not got a space there that's licensed. I'm doing that on the hoof to a certain extent, but it may be that you consider, if that area isn't going to be used for that purpose going forward, that you can put a condition on there that when licensable activities commence on the new space, then the other area becomes delicensed. It's a matter for you whether you seek to do that or not. The biggest concern that was raised to me, obviously, Mr. Semper's right. People can apply to vary a license at any time. It's enshrined in your license statement and licensing policy. It's in the section 182 guidance. And actually, as a matter of fairness, as a matter of supporting business, of course, we all want to support businesses and business to be successful, that run responsibly. It's absolutely right. Someone can sit down and go, well, what I've got now isn't right anymore, and I want to change it for these reasons. I've got a good business reason for doing it. But the concerns that the residents have expressed to me is that by creep, this venue is going to become something that it presently isn't, because I have to, Mr. Semper said this, there's been no issues raised with how these premises have been run today. Okay, I'm not going to sit here and say, because that I asked that question and nobody raised any concerns. The concern is that by creep, these premises are going to morph into something else. And unless these conditions are placed upon it, there will, by the back door, these concerns are this premise will not resemble what it does now if this application is granted. And so the purpose of today is firstly to invite you to impose those proportionate conditions on the licence in order that the concerns of the residents, in accordance with what was said at that meeting, are addressed and enshrined in the licence, so that everybody is clear what this licence is and what it's going to be if this application to vary it is granted, which I expect it will be. And secondly, for me to go on the record to say at this hearing today that there are concerns that this will be part of a series of steps to liberalise this licence to an extent where it will impact hugely. Now, if that doesn't happen, great. It means you don't have to see me again, at least not in this context. But if it does, then I've vocalised that and ventilated it in a public hearing. So I'm not going to make any submission that this variation should not be granted, because on the face of it, on the basis of what Mr. Semper has said, he is correct. It is a modest application, but I make the point that those 4, potentially 5 restrictions, limits on the licence ensure that what Mr. Semper says it's going to be, I don't doubt that Mr. Semper is acting on clear instructions in relation to that, it is what it will be, and that it will be limited to that in order that the real concerns of the people in this room are based on fear and speculation, and if that's the case, then everybody's happy. So thank you for listening. I think that deals. Let me just check my notes. I don't want to. No, that's it. Thank you very much.
Quite happy with your comments. Thank you. And they will be considered. Right, as there doesn't seem to be any questions from anyone else, if you'd like to would you like to come? Yeah.
Okay. Have a go at this. Right, the 4 requested conditions Mr. Craig has addressed you on. Traffic management plan. There's absolutely no need. It is already, the traffic management plan is already enshrined within the current licence that you put on there. Last time we were here in August, that there will be a 2-hour gap between those 2 tours. So never the traffic coming or going, never the twain shall meet. No person, limit of 30 persons to special events. It's already agreed. Thirdly, no amplified music. Right. Mr. Craig is asking that there's no amplified music or speakers at the premises. Why do we reject that? Well, the first thing to note is there's no element of regulated entertainment in the current premises license or the variation that lies before you. The second thing to note is there is no complaints or evidence before the committee to do with amplified music. So there is no need in my submission to consider the appropriateness or otherwise of amplified music on site. Thirdly, the third thing I should say is the Licensing Act doesn't specifically deal with amplified music at all, but rather deals with live and recorded music. Therefore, we are talking about something that actually lies outside the terminology of the Licensing Act. Yes, live and recorded music can be amplified, but so can a radio being played in the packing bay of the barn or in the bottle shop to set ambient music as people shop or visit for these special events. So I'm just not sure we need to go there because live and recorded music is not included in this application. Okay. And actually the live, not that they intend to do this, but live and recorded music is deregulated by on licensed premises between 8 and 11 to audiences of less than 500, but a Live Music Act is amended, and I throw myself at the mercy of your legal advisor to confirm that in private session. Therefore, in my submission, it would be simply inappropriate to impose any formal conditions on these premises regarding amplified music. Okay. And lastly, pre-booking. Well, that is another one. Mr. Craig has asked that we agree to a condition that any pre-booking shall be undertaken online in advance of attending premises. Well, with respect, that's already contained in both documents. Annex 3 of the present licence says that bookings are by appointment only for tour parties. You insisted upon that last time. And secondly, the variation application, it states very clearly, special events, all pre-booked, operating Monday to Sunday, 10 till 8. Okay? Pre-booking means exactly that, before the event. And it is implicit that this, in the majority of cases, will be by phone, email, or online. So with respect, Mr. Craig already has what he wants. And these features will be translated by Mr. Chislett into any new license if this application is successful today. Therefore, in my submission, whatever the ill Mr. Craig seeks to address on behalf of his clients, any extension of what is already offered above is plainly not evidence-based or appropriate in any way. And lastly, we have this further condition that the current existing barn is delicensed in the event that the new one is licensed. But there's absolutely no need to impose that condition. The applicant, the Wilcoxes, may well wish to use that pre-existing barn as part of their pick, pack and dispatch operation at busy times. There's simply no need to remove, delicense that old barn. And para 9.43 of the statutory guidance helps us massively here. And it says, clearly states, the authorities, i.e. your determination, should be evidence-based, justified as being appropriate for the promotion of licensing objectives and proportionate to what is intended to be achieved. Now, we've heard references to nightclubs opening next door. We've heard references to Glastonbury. Let's just take a step back and recognise what we're dealing with here. We're dealing with a de minimis quality operation that's been running for 15 months without causing any problems to anybody. Why would they suddenly want to open a JD Wetherspoons or a banging nightclub on this site? Why would they do that? And were they to do it, you already had the Section 51 review procedure to turn that ship around. Okay, so look, I'll just finish where I started. This hearing is simply about whether this premises license, varied as requested and operating under this operating schedule, is capable of promoting the licensing objectives. Clearly, my position is that it is. It is a small scale quality operation which has to date and will not in future adversely affect or impact on anyone. Consequently, I respectfully ask you to grant this variation as sought, supported by the already comprehensive raft of effective conditions, and in doing so, you wish this modest but supremely successful vineyard every continuing success going forwards. Thank you for your time. Thank you.
Don't worry, I won't be more than a couple of hours, promise. I'll just deal with those conditions. First of all, I don't think Mr. Semper's right, actually. I don't think the limit of 30 is contained in the application, because that's why I asked the question. So, if that's conceded, then please place that as a condition on the licence. We're perhaps Mr. Semper seems to have conceded that there is a traffic management plan. He just doesn't want it as a condition. Well, okay, fine. That's a matter for you, but I would say there's no reason to not impose that as a condition in order that it's enshrined in the licence and the concerns of these local residents are suitably addressed. In terms of the, you mentioned, Mr. Semper mentioned about radio. In actual fact, broadcast in any event under Schedule 1, Paragraph 8 of the Licensing Act is exempt as regulated entertainment in any event. But what we're seeking to do is simply reflect what was said at that particular meeting in order that, again, the concerns are properly addressed. Again, the pre-booking, simply the objectors are simply seeking to clarify what pre-booking actually means, because unless it's defined in some way, then nobody knows what exactly a pre-booking is or isn't. In terms of the licensable area, that is a matter for you. So again, Semper is doing what I would do if I was sat in his shoes and pointing out that any step that you take needs to be appropriate and proportionate for the promotion of the licensing objectives. I agree. All I am seeking to do today, and I'm limited to this, but I'm seeking to do is to invite you to ask you those matters that were conceded at that meeting by the applicant to the objectors, and that they are enshrined in the licence and converted to enforceable conditions in order that their concerns are properly addressed, and whether that's already in the application, whether it's been conceded by Mr. Semper or it's based on the submissions that I've made, that's what I'm inviting you to do in order that hopefully we don't have to be back here again. Thank you. Yes, thank you. Yes. Thank you.